This is an innocent successor liability bill. The current rule of successor liability provides that when a predecessor merges with another corporation, the successor can be held liable without limit for the torts of the dissolved predecessor, even if the successor did nothing wrong and the activity of the predecessor that created the liability was terminated before the merger. In some circumstances, the rules can cause tremendous injustice, as in the case of who I'm talking about today, Minnesota's Crown Cork and Seal, a company founded back in 1892 by the inventor of the bottle cap. This brief relationship with Mundet has cost Crown Cork and Seal over $750 million in asbestos-related expenses. Moreover, Crown Cork and Seal's credit rating has been reduced to junk status, and the company has subsequently been forced to pay junk bond interest rates on its borrowing, resulting in over $1 billion.
The facts are that Crown Cork knew or should have known of the liability that they were buying. And that is indeed what they did. They bought a company that had already experienced a number of asbestos-related claims in their workers' compensation policy. Mundet's own records, the company that was bought, their own records, and copies were shown in Judiciary Committee, their own records showed a list of the asbestos-related work comp claims that they had already experienced. So, as the old saying goes, caveat emptor, indeed, Crown Cork knew what they were buying, or they certainly should have known. And whether they blame it on, bad due diligence or whatever, I have been informed that, in fact, there are deposition transcripts from litigation in which Crown Cork acknowledged that they knew that Mundet had experienced asbestos-related liabilities before Crown Cork bought the company.
You have a business that has never been engaged in any activity that has created any harm to anybody. That's not the business that they're in. And so it's really surprising to me that we want to hold liable to what you've called innocent victims when they actually have no relationship whatsoever. The innocent victims that you talk about were harmed by the activities of a business that is out of business. That entity no longer exists. Why are we going to hold a completely unrelated business liable for harms that they can't possibly be responsible for, except in some contrived lawsuit filed by a lawyer looking for deep pockets?
When I heard the bill addressed by Senator Parry, he talked about this being an innocent company, and he talked about the victims as being alleged victims or possible victims or something of that sort. And the fact is that some people were hurt by asbestos. Some of them get bad forms of cancer. A lot of them die from it. My question is, who should they have recourse with? Should the public provide funding for people who are sick and making sure that people who might get cancer and so on have care? If it's not the company that you're saying is an innocent company, even though they've made profits off of it, who should address the needs of these people? Because they are truly people, whether you're calling them apparent victims or not, they are people who have asbestos-related health issues, often cancer, often terminal. Who should take care of them? I don't mind if we want to change our whole system and not rely on the responsible companies or the, quote, non-responsible companies and say it should be the taxpayers, but I'm wondering, who should? Should we just say, well, you got cancer, shouldn't have worked there, should have known better? Because they have no other recourse in a case like this.
Senator Thompson. Madam President, thank you. I would like to address the issue raised by Senator Marty, and the answer is that if there is a legitimate tort case there, if somebody has committed a wrong that has resulted in the cancer-related disease, then the potential plaintiff would have a claim against the company that caused it. We're dealing here with the company that did not cause it. And by the way, yes, health insurance would cover that treatment. Health insurance doesn't ask how did the cancer come about. If the individual has health coverage, it would be covered. So the answer is twofold. Your health insurance would cover the medical problem, and if in fact there is a tortfeasor out there that wrongfully exposed you to the asbestos, you can still make that tortfeasor a defendant.